Again, my name is Sara Huerter. I'm a shareholder with Carpenter Chartered. I've been practicing VA law for over 20 years. Um, I'm joined today by Laura Chapman, who will also be presenting. She's an attorney here. She joined us this year, and prior to that was working with Chicago Legal Aid doing veterans law. So she has several years of experience. Today's presentation is about essentially boils down to client communication. I think it's one of the hallmarks of our success. It's something that is very critical in this. I mean, it's critical in all probably legal practice, but especially in this area. It's, you know, you're going to get repeated denials from the VA on cases that are the least bit complicated. So staying in touch with that client and explaining the process just really um, makes that better. I mean, they can not that they love denials, but that makes it much easier if they at least know what's going on and are involved in the process and involved in the decision making. With that being said, we're going to cover three topics. One is frequent talking points, which we'll discuss, and then we will discuss what constitutes legal advice. This is designed, we've done this presentation before internally, and was mostly, geared towards our paralegals, but it's an important distinction to understand uh, when what they should be talking about versus what the attorney should be talking about or the agent with the client. And then lastly, we'll discuss what you should do when your client passes away. So I will pass it over to Laura to get us started.
Is Sarah? I'm going to share my screen. Click. Okay, everybody's seeing a gorgeous PowerPoint. Good. Okay. Also, I don't have like the chat up, so if you have a question while either of us are talking, just feel free to unmute yourself and go crazy. So overall agenda, like Sarah said, we're going to be talking about these three different topics, but ultimately all boils down to client communication. Let's talk frequent talking points. So initial strategy calls with clients. This is probably one of the most in-depth like conversations you will have with a client. Preparation is key for these conversations. Taking notes ahead of time and taking extra care to figure out how to communicate difficult parts of the VA process or complicated issues that we're dealing with when it comes to someone's claim. So I have been practicing law for like 3 or 4 years now. I started off in legal aid, like Sarah said. I used to be so scared of calling clients that I would write out everything I thought I would say, literally down to, hello, my name is Laura and I am your attorney. I don't do that anymore, but I still make bullet points for myself when I'm going to call a client and talk through the important stuff. And it helps me every time. A lot less forgetting questions I wanted to ask. So it's helpful also to make a list of decisions that you'll need client to make when you're discussing things, whether that's, hey, you need to pick some people you're going to ask to write lay statements for you, buddy statements. You're going to need to pick if we're discussing like, one strategy versus another, the client might have to make a decision about that. Make a list of questions about information you need from the client. So we still need a client's DD-214. It wasn't in their file. We still need something from the client. Make a list of those too, so you can get it all out of the way in one conversation. Taking cues from your client. This is a huge one. If they seem uncomfortable, upset, angry with where the conversation is or what you're discussing, feel free to pause the conversation to let them know that we can pick up where we left off later if necessary. This is always helpful when it comes to starting to talk in detail about claims or talking about, just life in general. People get upset, they get angry. It's always okay to kind of pull the call over, so to speak, and let somebody know we can discuss this later if this is getting to be too much. Make sure you pause throughout the conversation to let the client interject with questions or concerns. I am a person who talks a lot and will talk very fast. I try to do a good job of pausing. I don't always do that. So I always make sure when I have finished whatever I am saying to ask client if they have any questions about what I just said and let them know, call or email me if you have questions that you thought of, but I was busy barreling ahead, so you forgot them. In the initial calls with clients, we want to outline what the goals are and get their input on goals. This is a collaborative process, so the client might have a totally different understanding of what they want to get out of working with us than we do. So we might do intake on a case and see, oh wow, like, looks like we could get maybe benefits back to 1985 on this. The VA, never issued a decision on this, blah, blah, blah. We might let the client know that. They might say, okay, but what I really want is TDIU, like right now. So people are going to have different understandings of what they're trying to get out of this process. You might tell them about, hey, we can get back benefits all the way back to this, and they're like, oh yeah, like, go crazy, go nuts with that. But it's important to be on the same page about what you're trying to achieve for client. So they're invested in the process. Clients have these claims are their life, they're about their life. And often have been dealing with trying to get the VA to grant them for 30, 40 years. And they're often looking for results that we cannot get them as their attorneys and representatives. I have had clients who just want to be in front of a judge or somebody who works at the VA so they can tell them exactly what they've done to them and exactly how mistreated they feel. A common complaint is that no one has really listened to them, whether that's doctors, the VA, the government, the military, or other attorneys, other people they've VSOs. Like this is what I hear the most is that people haven't been listened to. So absolutely validate a client's feelings with regards to their experiences with military, the VA, whatever has gone on, and let them know that pursuing a claim is a way to make sure the VA gets their side of the story. This, of course, doesn't mean that the VA is going to say sorry, which is often what people are looking for. They're looking for an apology. Be honest with them, let them know that that's not something that, even if we get $1 billion from the VA, it's never going to come in a package that says, hey, we're sorry about that, which stinks. But we have to set a realistic expectation. And we can reinforce that with the client by letting them know what a win is. Don't promise anything to a client that we can't guarantee. We absolutely cannot ever promise that a specific outcome or award will happen. We just do not know. But we can promise to use all of our expertise possible to achieve a positive outcome. Let's see. Clarity. Clarity, super important. Using flowery, legal, complicated language, and all of the huge amount of abbreviations that we use in this type of law, difficult for clients. Striving for plain language is super important. We want to communicate quickly, easily, and as completely as possible. Most adults in the United States read below a 6th grade level. So talking to people in conversational ways, I find is the best way to communicate information that's complicated. This is not to say talk down to people. That is absolutely not what it is. It's being clear and being respectful by communicating exactly what you want to convey. This is something that they don't teach in law schools, unfortunately. I had a lot of different classes about trust structures and stuff like this. When what I really should have been learning is how to talk to people. You want to avoid overuse of specialized words and take extra care to explain each weird thing or abbreviation. So say I'm talking to a client about, what we would like to do is file a higher level review. We're looking for an earlier effective date because there was an intent to file that had been filed. So that's 3 abbreviations in one sentence. It's important to break down for client exactly what each part of that is, go into detail about what a higher level review is, what we're asking for when we file one of those, who is a higher level reviewer, what do they do, explain what an earlier effective date is, on and on. Think about what you're communicating to the client and which parts of that need to be communicated. Some clients already know this stuff. I have clients who've worked for the VA and are well aware of what these things are. And that's okay. You can adjust your messaging, but explain in detail what we're doing to clients. We have to collaborate with our clients. That's the whole point of our relationship. That's the whole point of having an attorney. Our job is to present strategies for success and then make recommendations to our clients about what we think we can achieve and what we think the best path forward is. Our clients listen to us and our recommendations hold weight because of our expertise as people who do this type of law and work in this area. So I find a lot of the time a client wants to do what I recommend is the best path forward, but it is ultimately up to the client to decide how they want to proceed. That's key here. I'm not from like a family with lawyer. I didn't know anything about law before I became a lawyer and went to law school. So for some reason, I used to think like when somebody said they reached a settlement, like it's just the attorney, like since they're the one doing it, like they made all the decisions. Come to find out, that's not how it works at all. You, as the client, are the person who has the final say in what you want to accept. Um, so I always try to keep that in mind when I'm thinking about strategy, what I'm doing um, with a client is, ultimately if you're waffling on something, it can be helpful to call the client and talk to them about the strategies that you see and get their input. Um, CMP exams. This is something I do a lot of talking with clients about. Um, they want exams to go well. We do too, obviously. And preparing a client for an exam is a really easy way to help them feel more at ease with the process. A lot of people that we are working with have been to tons and tons of CMP exams already and have not had good experiences. Um, I find it's helpful to talk with a client about what is going to happen and having them think about and write down everything they want to say to the VA. So will just sort of, I'll be the CMP examiner, and I'll ask them to tell me about their symptoms, severity, to kind of draw that information out of them. If it's something, if a disability is something you live with every day, it's not necessarily going to be top of mind. Oh, how many times per week do I have this symptom? Whatever, it's something you've learned to live with, and maybe you take medication for it. But kind of drawing this information out of a client to bring it top of mind to them, what they experience. Clients will often say, should I stop taking my medication or not bring my assisted device or do something to exacerbate their condition before an exam? Say no to that. Uh, Tell the client that they need to go in and honestly describe how their disability affects them on its worst day, on its best day to the examiner. What we do not want people doing is stopping taking their medication and showing up to the exam and hoping that it works out for them because honestly, it's probably not even going to make a difference in what the examiner does. Like I said, talk about what they're going to experience at the exam. They might be well aware they may have gone to, 10 different mental health exams at this point before they get there. Walk through the DBQ form. So each CMP exam has a specific form that the examiner is using as a guide to do the examination. So I will just pull that up while I'm on the phone with client. I'll send it to them if they ask to look at it too, but I'll let them know that's what I'm looking at. And this is what questions the examiner is going to ask. I ask my clients to say everything they want to say to the examiner, even if they aren't given the opportunity to. So I have clients who will tell me, oh, the examiner asked at the end of the exam, like, is there anything you want to add? Not all examiners do that. I really emphasize with people that, you know, it's difficult. You're in a position where this person is making a decision about what you're entitled to. They're a physician. People have complicated relationships to medical professionals. So telling a client, you need to feel like you can say what you want to say during this exam, no matter what, I think is super important. Um, Clients have had varying experiences with examiners in the past. I always tell a client the examiner might be rude, they might be dismissive, they might seem like they are not listening at all, they might ask you one question. Um, I always ask a client to just give me a call or email, let me know how it went. If it went good, that's great. We'll talk about that. If it went bad, I ask them to write down what happens as soon as they get the opportunity to, and give me a call. We'll talk about it. I'll make sure that it's in our records. So that on the back end, when we get a decision back, we can take a look at what is in the CMP exam and what actually happened, based on what the client said. If an examiner is really, really bad, we can always call the VA or the contractor and let them know. But a lot can go wrong at these exams, and I always prepare clients for that too and let them know. You can show up and, the example I use is, I had a client who was wheelchair bound, and he showed up to a CMP exam. He had to drive like 30 miles away. He gets there. There's literally no way for him to get in the building. There is no curb cut. There is no ramp. Like, he cannot get into the office where the CMP exam is in a wheelchair. So the VA said, you didn't show up to your exam. So that's something we definitely want to know, and communicate as soon as possible. Case status updates are, I would say, the bulk of what my conversations with clients are. A lot of times clients are frustrated, understandably, with how long they've been waiting. Just, what's the decision going to be? I don't know what's happening. General unpredictability of the timeline. What I like to do is break down what's going on and what the path forward is at that point, describe in detail what we're waiting to get back from the VA. So if we're at a point where, like, the VA hasn't even ordered new exams, we're expecting that, I'll let the client know, I'm expecting you to have to go to another exam before a decision is made, or we're just waiting on a decision, or the board has remanded your case and it's going back to the VA. I also like to talk forward with people a little bit about what happens once we get a decision. So whether that's negative or positive, what those might look like, issues we might have with those. So we might get a positive decision. It might be from the wrong effective date. In fact, I can almost guarantee that it'll be from the wrong effective date at this point. They're pretty much never right anymore. Talking through and letting them know, what direction things are going to take after a positive or negative outcome can be helpful too, because people feel a little more prepared for getting the decision. Explaining and emphasizing what positive developments there are. So just because there's not a back pay award and ongoing benefits, clients sometimes have a hard time recognizing what are positive things. So things like favorable findings in a decision that's, doesn't grant, remands coming back from the board, good exams that we see come through. These are all things to really emphasize with your client that are positive developments that have a big effect cumulatively. So even if, the decision that we get back is negative, these are things that we're building on, to use to move to where we want with their claim. Uncomfortable conversations. So clients are often angry and upset about case progress decisions. That's totally normal. I would probably be angry too if I was in their position. That's fine, but if a client ever directs their anger towards you, makes personal attacks, or makes you feel uncomfortable, you should feel empowered to end the call immediately and let the client know that the conversation will resume later. So this, unfortunately, is a lesson I had to learn very quick. I started my career in legal aid, in a very unpredictable area where I was doing I did veterans benefits works, but I also did anti-eviction work with people who were like appointed legal defense. So I talked to a lot of really angry people, clients, landlords, other attorneys all the time. Um, it's okay to be angry, but if you're going to make it personal, be hateful to a person, um, just hang up. Well, say, hey, I think we're done talking, and then hang. It's totally fine. Often I find that people know that they're messing up when they do this. I cannot tell you the amount of times that I've had a conversation like this with somebody and they call me back in a couple days and are very apologetic. It doesn't always happen, but often it does. People realize they're in the wrong and, may have popped off the handle, things like that. Um, if you ever have concerns about something a client says to you, don't hesitate to contact your supervisor for guidance. That supervisor can always call the client for you, let them know that certain behavior wasn't appropriate, follow up with them. In particular, if you have a client who is expressing that they want to harm themselves or someone else, let your supervisor know, and we can kind of assess the situation. Attorneys do have obligations in most states to report if someone is making a credible threat of harm to others. It's a pretty high bar to reach, but that's something that you don't need to like carry alone. Like reach out to someone and let them know what you talked about, and we can take it from there. I think that's everything I wanted to talk about with client communications. Any questions for now about this topic? Oh, let me read some chat things. Claire said, if I may, I also recommend in your initial call, you explain if and when how exams get scheduled. Absolutely. This is huge. Thank you, Claire. Because a client gets a letter in the mail, they get a call, they get an email scheduling an exam. We, as their representative, do not get that. Like it goes in their C file, the examination request letter, but I cannot tell you the amount of times a client has called me and said, I've got an exam, and I go, okay, that's great. Let's talk about that. And they're surprised that I didn't know that already. And I have to explain, I don't get that information. That's something that the VA does themselves. And yeah, like Claire said, emphasizing that this is a contractor, this is a third party. We can let the VA know if you had to miss your appointment, things like that, but we are not in charge of scheduling. And honestly, the VA hardly knows what's going on with the scheduling. So yeah.
Hey, Laura.
Mhm.
I apologize if you said this and I missed it. You know how you were talking about getting clients ready for exams and writing down absolutely everything they possibly want to say. How do you feel about having them hand that piece of paper to the examiner at the exam?
I think if that's something that the client is comfortable with, I would say go for it. I don't think there's like any harm that can come from it. The worst thing is, that the examiner just goes, or, doesn't look at it at all. I would be interested to see how the examiner deals with that, honestly. Like, are they, because I don't know that the examiner has a way to like put that into the file other than like writing it out. So I think it's a good strategy, and especially for clients who absolutely, are like, I gotta tell them this, I gotta tell them this. It might be something that's good, and helping clients come up with like a template or something, or I mean, us coming up with a template that clients can kind of use to communicate to the VA. I think that sounds great.
Yeah, the few times I've known, I mean, in the past, I've had clients take in affidavits, but the examiner doesn't do anything with them. I mean, we submit them obviously separately. And then, from what I know, I've never seen it end up in the e-folder, but if someone else has, I'd be interested to know
Yeah.
if they proactively do anything.
Laura, I have two, I guess, statements, not questions necessarily, but so one thing that I do specifically for mental health is when I'm talking to my clients, and I don't tell, obviously I tell them to be honest, obviously, but I tell them to kind of go in with the mindset that it's their, like, one of their worst days,
Mhm.
they think about that instead of, obviously saying, oh yeah, I'm doing great today type thing. And have them understand why we say that. And then also specifically again for mental health, because that's what I'm primarily focused on with them, is bringing somebody with them, bringing their spouse or whoever takes care of them or whoever, knows them best, so that they can help them remember that stuff if they're not bringing something in from written guidelines or whatever.
Yeah. No, that sounds really great. The focus on, especially for mental health, it's not the same as like your knee is messed up or something like that. Like flares are a lot different in a mental health scheme. So absolutely letting them know like describe what your worst symptoms are. Because I mean, I can't tell you how many times I've seen somebody, somebody will end up with a mental health reduction because on the day they went in for their exam, they were doing a little better than normal. And the examiner's like, oh, this isn't 70%. This is clearly 30. It happens constantly because somebody comes in and has one good exam. And of course, we'll fight against that and say one exam is not determinative, blah, blah, blah. But thank you, Tina. That's absolutely a really good thing to emphasize with clients. And then,
If it worsened, it just started that day that it got worse.
yeah.
The one that always makes me laugh too.
Now I'm back at 70%. Thank you very much. And then what was the second thing you said, Tina? It totally went out of my brain.
Bringing somebody with them, specifically like a spouse or something.
Yeah. So clients can bring companion support persons with them to exams. That's great. I have a lot of clients who like I talk to their spouse more than them because that's the way that they want it. Like their spouse is the person who like is in charge of like getting their healthcare scheduled, making sure they're at their appointments, like really, and is a caregiver, and is dealing with their symptoms firsthand. So I have a lot of clients where the spouse is the main person who has a lot of information. The also sometimes I'll talk with female clients about the ability to ask for a chaperone or a specific like same gender examiner. So as a woman, you can request in particular that you would like a female examiner, and the VA and the contractors should honor that. In the alternative, you can ask for a chaperone to male or female if you just feel like you want someone else in the room, you don't have anybody. That's always something. So especially for cases that involve MST, I will emphasize that with clients that they're allowed to have another person in the room, whether it's a support person or a chaperone, to make sure that they feel supported and safe describing those symptoms. But yeah, I think that's everything for me. So I will stop sharing.
Sorry, can I I want to ask a question because I recently experienced something and I have a client who's incredibly anxious. Like he's rated at 70%, but when I say anxious, I mean any communication from VA, any email, text, contact from a third party.
Yeah.
That sends him into a full-blown panic. Well, of course, I can't remember what the whole details was, but we got to the point where he had a mental health evaluation and he was upset that he had one. And so the entire time, against our advice, he fought the examiner and was basically saying, you should already know this, it's in my record. And so the report comes back and it shows veteran is combative. Veteran will not answer questions directly. Veteran, and it's like going on. And I called him and I said, hey, this is what it looks like. I just want you to know, like, it's not really what we talked about, but hopefully the information was really well. Of course, VA doesn't like that, so they proposed to reduce him, and we request a hearing, and they say, okay, well, we'll reevaluate him. There's another mental health exam reevaluating him to not reduce him, and once again he's combative. And he called me and I can't believe they're doing this to me. They should understand what they're doing. And I'm trying to offer empathy and, remind him that the people doing the exams are not the people making the end decision on their report. They're just there to take the information. And, and of course he sees them, the examiner, as like the the problem itself, trying to explain to him that's not really the case, that this person doesn't know anything other than what they're provided, and they're not usually intentionally doing something to ruin their case. So of course that comes back and they're like, that was not a good exam. We're ordering another exam. And I'm telling you, I finally had to just give him a little tough love, but I had never experienced this before. I've never had a client who was like just so adamantly like he was almost making it worse on himself. And I was like, well, you cannot go to the exam. I was like, no one's going to force you to go, but if you don't go, they're going to reduce you. I don't know how else to tell you. And he ended up having to have a whole conversation with Alyssa about this, but I had never experienced a veteran be so adamantly like angry. He was, and I kind of had to stop him and just say, I hear what you're saying, but I don't think you're coming at this logically. And I felt so bad saying it, but I think he needed to hear it. I just, I don't know. I don't know if anyone else has ever experienced them like almost ruining their own exam by just hating the fact that they're there.
No, this is huge. Like, part of this and part of like, I've dealt with this in Social Security also is like a client's ability to participate in the process is innately tied to their mental health. So I have had clients where they will not go to another exam. So say they're at like 70 and they should really be at 100. I cannot get them to go to an exam at all. I would have clients in Social Security context too who would refuse to go to the disability evaluation. And it gets really complicated. I kind of like last ditch thing sometimes I have tried is like talking with hopefully they have a clinician. God willing, they have a clinician or a therapist that they're working with and having them like explain in a letter how their symptoms make it difficult for them to participate in this CMP process, how many exams they've had, how frustrated they are, like that they have anger issues, that they have. That's something I have done in this context too, just because I've had the same experience, just a client who was like, they know all this. What am I even doing this for? I hate them, like whatever. But yeah, it's a super, super difficult position to be in. There's only so much we can do. And of course, not showing up to an exam, the VA is always going to view that unfavorably. Even if I write them a letter saying, hey, this is the 20th exam this person's had in 2 years. Can we stop? But yeah, just it's hard. I will say this is like an option too. Not for mental health. This is not really helpful. But I have had clients where I have had to get them an at-home exam. So I've had a client with like super severe agoraphobia as part of their mental health claim, and like they cannot and will not leave the house. So that's something that is always available to request. It's hard to coordinate with the VA, but it's something they have to accommodate if that person needs it. If they are insistent that like we need an exam. So I don't know. I doubt that for that person, that would be for some people that is, I mean, not a welcome intrusion into their life,
I
but
did
that's another
talk him
option
into
too.
telehealth. I was like, maybe we shouldn't be going in person because I feel like that's
Yeah.
triggering, like you're out of your comfort zone. And he was like, well, okay, and
Yeah.
but still, just like the most, like I had never had to give such tough love, like verbally. I've sent, tough love emails, like I
Yeah.
understand, I'm showing all the empathy I can and I want to express that to them, but I had never had to like say to him on the phone, like, client, there's just here are your options. It is you either go or you do not go. But if you go, please participate
Yeah.
kindly. Look at that examiner as a human who is not going in with any judgment as long as you go in with no judgment. And that's tough.
No, it's tough. I applaud you.
I think one of the most useful things I've learned in my 5-ish years of doing this so far is that sometimes you just can't help them.
Mhm.
And that's tough and it sucks. And I do everything in my power to help them. But we can't do it on our own, right? Like we need them to help us help them. And I'll explain that to them if they're having a hard time with it. And I don't know, sometimes you just have to read the person, because sometimes they respond really well to the tough love. And sometimes they need a little bit of a softer touch. Or if you have a third party release and there's a family member or a close friend who they've authorized you to speak with, you can, ask them to lean a finger on the scale, lean a thumb on the scale for you, trying to get them to cooperate. And also, I think in general, people who are in that headspace tend to think that everyone at VA is collaborating against them. And so just trying to explain VA isn't possibly skilled or capable enough to do that. And this is just individuals who have their own internal pressures. And we need to look at it from their perspective.
Yeah, I don't know how many times I've had the conversation, Claire. That's the VA is not working with the specific intent to deny you claims. Unfortunately, this is how they work in general, and no one has a specific agenda against you. Is difficult to explain, but yeah, we have to have. We're invested in a client's case. We need them to invest as well when it comes to collaborating with the process, and sometimes we cannot get there. So I will stop sharing and hand it back over to Sarah for the rest of the presentation.
Thank you, Laura. Good job. I was just going to mention too that, yeah, Michelle pointed out that you can find the DBQs on the VA's website for every condition. Let's see. All right. So my topic is about what constitutes legal advice. And as I said, this is, something we kind of had for our paralegals. And when you're talking about client communication, you want to make the distinction between giving legal advice versus legal information. And what is the practice of law? What does that entail? So we'll go through a little bit the practice of law, the scope of duty for attorneys and non-attorneys, legal advice versus legal information, the model rules regarding communications, and the unauthorized practice of law. And then feel free to jump in with any questions you have. So, as I'm sure everyone knows, you have to be eligible to practice law. You must be admitted to a bar. So I'm admitted to the Kansas State Bar, but I can also practice in VA law because of that, because you just have to be admitted into some bar. But each bar has its own rules of professional conduct that attorneys have to comply with. There's a disciplinary committee that you can get reported to. You can get an informal admonition, a censure, probation, suspension, disbarment. So these are, just a set of rules that we're operating under. Non-attorney agents are required to get accreditation to practice VA law. And then VA has its own standards of conducts for representation at 38 CFR 14.632, which essentially model. These are all, they vary somewhat, but they're pretty consistent across the ABA. So what constitutes the practice of law? There's no definition. When I looked it up at the ABA website, they proposed a rule back in 2002. They have not adopted anything. This is their proposed rule. And basically it's been left up to individual states to define what they consider the practice of law. But yes, whatever we define it as, which, it makes sense. It's applying facts to the law. But you have to be admitted to practice law in the jurisdiction, any jurisdiction you're practicing in. So if I, wanted to practice at the federal circuit, I'm not admitted to the federal circuit. So I would have to go and request permission to practice there. So non-attorney staff cannot engage in the unauthorized practice of law. But a lawyer can employ a non-lawyer to do any task for them, essentially, but counsel clients about law matters, i.e. engage in the practice of law. If a non-attorney is providing legal advice, that's when it can get tricky in terms of violating the ABA model rules 5.3 and 5.5. So ABA model rule 5.3 discusses the attorney's scope of duties with regard to non-attorneys that they're working with. Basically, you just have to have the direct supervisory authority over what they are doing. And then you're responsible for their conduct. And yeah, again, direct supervisory authority. So that's the model, that's the ABA's model rule at 5.3. So essentially, your supervising attorney is responsible for every professional action that you take. As you know, when we're working with our paralegals, and even, you know, under VA law, we, like Laura practices, but she's under my power of attorney. So I'm, you know, responsible for her actions. So there's a lot of leeway there and a lot of trust that has to develop, but that puts the onus on me to make sure that things that are getting submitted are, you know, if there's errors, the fallback is on me. It's basically. And then the big one here that we're concerned with is, you know, what's that line between when you're talking to clients, are you giving legal advice? And that wanting to emphasize when you should probably defer to the attorney when the client is asking you questions. So, as I said, we can delegate almost everything we do to a non-attorney, except for establishing that attorney-client relationship, which in general, you know, we do with our signing the POA, establishing the fee charged, and providing legal advice. Legal advice is interpretation of the law, applying the laws to the facts of the case, and providing guidance on how to proceed. So it's, you know, applying the application of the law to the client's specific situation and recommending action. It goes beyond just, you know, providing legal information. Courts often use a legal advice first legal information framework to help guide employees on what questions can be answered. A non-attorney can provide legal information, providing information about deadlines, how the VA process works, etc. That's just legal information. If a client wants to know what they should do, that is legal advice. Again, that's, you know, defining what legal advice, it's interpreting a case or regulation or VA procedure, applying the law to the facts of the case, and recommending a course of action. If you're not sure if you know, if it's something you can answer, the main thing is asking, is there more than one possible answer to this question? And that's probably legal advice versus just legal information. If the question begins with should or whether, but if you could find the information they're asking on the VA's website for the most part, then that would be most likely legal information. It's about something that has just one answer. Under the model rules, when you're communicating with the client, the two most common bar complaints brought against attorneys are the negligence, which is, you know, you literally missed a deadline, or the lack of communication. This is what a lot of clients will end up filing bar complaints about to their against their attorneys, because they get really frustrated if they go a year and haven't heard anything. And this is hard to balance in the VA world when we're sometimes, especially you've taken the case to the board, you know, there's not going to be any decision for 2+ years. And that's, you know, on the kind side. So, you know, this is where it becomes important to just keep checking in with the client every, you know, calendar. We try to do, I think, at least every 6 months, and just say, hey, by the way, we know you're still out there. We know we're still waiting for a decision. remind them, you know, if there's anything that changes that we can advance, let us know. But yeah, I mean, it's just a reasonable standard, reasonable updates to your clients. So model rule 1.4 covers the communications, and I just include these to have these model rules to have the citations. We don't have to read through them all, but again, pretty just a reasonable standard. Try to keep them reasonably informed. Under these model rules, most of this can be delegated to the paralegal or any assistance. The reason we, you know, like I said, the reason I think that it's important to go through these things is because it's not only an ethical obligation to communicate with our clients, it's also one of the key factors to our success. Is you get a lot of if you have clients coming from other places, or they have experiences, and especially then they're dealing with the VA where they feel like they've had no communication. So it's really important to them to, as Laura was talking about, this is the first time they feel like usually someone's really listening to their story, even if they're saying, well, we can't really do that because of this. They just want an explanation, and they're not getting that. Especially from the VA, is, you know, they just want someone along the way to say, and you know, when we do intakes, we have cases like this where they've been trying for years to get something because they think it should be, you know, their case should go all the way back from their date of discharge, and they've just never had, even if we're not taking the case, they've just never had anyone say, this is why this isn't possible. So it's just very important. Also, when you're talking to the client, because a lot of times the non-attorney's job will be about, you know, I'm asking you to gather information for me that I need to make decisions. And along the way, when you're talking to the people, they want to know, okay, well, what's this gonna do? Do you think I'm gonna win on this or whatever? And you know, we paralegals have the same response there, which is usually, this isn't a question for your attorney. Anything that's, you know, about what the next step, or you know, what the plan is, or anything like that is, or if they bring up issues and they're like, do you think I could get this service connected? It's just standard practice to be like, I will record this and let your attorney, you know, make sure your attorney reviews it and reaches out to you if needed. And then yes, it's important that the client understands if they're talking to an attorney versus a non-attorney. Now, they won't remember this usually, but at least, you know, try to make that distinction. Identify yourself as I'm the paralegal versus, I always say I'm the attorney. Half the time when we hang up, they say, you know, or not maybe half the time, but every once in a while when they hang up, they're like, okay, nice talking to you, Tina, you know, talking about my paralegals versus me, but and trying to make it clear to them that no, this is who I am in this process. Oh, and yeah, just in our firm, if they are calling with non-VA legal questions, I usually, you know, do the standard, this is not my area of expertise, but try to direct them to resources if I know about them. Usually their local bar, to try to get those questions answered. So that was just, you know, a fast overview of what constitutes legal advice versus legal information to consider when you're talking to your clients and deciding, you know, what's that line where I need to actually refer this to the attorney, or at least check in with them to see if I can answer this question. Are there any questions about that? Okay. So if there's none on that, I will.
I'd like to ask a question, Sarah.
Yes, Adam.
Yeah. Can you talk a little about the different ethical standards as far as legal advice for non-attorneys who are accredited and non-attorneys who are not accredited.
That's interesting. I don't know that I wonder if that regulation covers that situation. So I think that you would have, I mean, I think the main thing you'd need to make it clear to the client that you're not accredited, but
Mhm.
as an attorney, you should still be able to provide legal advice.
I mean, I'm not an attorney. I'm an accredited agent. So my understanding is that if the questions are specifically about VA law, that I can say, like you said, I'm not an attorney and make that clear, but discuss VA law and
I was
then,
thinking, yeah, I was
if the
thinking,
yeah.
I was thinking you were talking about an attorney who was not accredited, but yes, I
Oh,
think
yeah.
I think under the model rules, or I'm sorry, not the model rules. I think under VA's own rules, you are allowed to give, I mean, you identify yourself as an agent, but
Mhm.
you're allowed to provide legal advice.
Yeah. And I've even gone to legal clinics like at the Denver Indian Center and said, if you have any questions specifically about a, a VA case, I'm here and happy to answer them. But don't ask me about anything that's not about, VA law, which I also, if I'm on the phone with a client who's a veteran or a claimant who is, family of a veteran, and they ask me anything that has to do with law outside VA, I instantly say I can't answer that, and try to refer them out, you know.
Right.
Yeah.
Yeah. Which we kind of, I mean, I even do the same, even though, there's, because it's kind of a fine line. You're like, some of this I could answer, but always with the disclaimer of like, I don't practice in this area. But
Yeah.
yeah, no, I think that that's the kind of the unique thing about VA laws, that the agents are, you're held to the standard of attorneys in terms of what you're communicating.
Mhm.
And so when I say non-attorney, I'm talking more about like paralegals,
Yeah.
or people who aren't accredited with the VA, and that they are, if they're trying to give legal advice, then that's unauthorized practice of law. But you trying to give legal advice would not constitute that, I think, under the way the because of the VA's regulations allow you to do that specifically.
Yeah. And, a lot of the people who work in VA law who are not accredited and not attorneys who have been paralegals for a long time are extreme experts in the process. And I think that's a good, conversation is when does advice about the process sort of stop and bleed into legal advice, you know? So thank you for answering my question.
You're welcome.
Yeah.
Seeing, yeah, Claire said, I'm an attorney, but still won't answer non-VA questions because I'm not licensed in their state. Exactly. And that's kind of the nice catch-all of like, I can't say that. Go to your state bar if you need advice. Okay. So then the last topic we wanted to get into was what to do when when you find out that a client has passed away. So we're generally informed by a surviving family member, or some other contact of the client that our client has passed away. You can also find out because the Social Security Administration has notified the VA. And then unfortunately, sometimes it's because we can't get a hold of our client and we don't, their emergency contacts we're not able to reach them either. And so, we will try to do a search of obituaries to find out if someone has passed away. But sometimes usually you can now find them through obituaries. It used to be that Social Security you could actually go search, but that has stopped. So you're kind of stuck with those options when you lose contact with the client. So once you find out that a client has died, we try to immediately download the e-folder to get the most recent version of it, because we'll lose access to that pretty quickly. And then we are talking to trying to identify that, do they have a surviving spouse? Do they have a surviving children? Or is there someone who bore the last part of the expense of the client's final sickness and burial? If we have claims that are pending that we want to substitute in for those pending claims, then we're doing that. And then if it's someone who's eligible for dependency and indemnity compensation, also need to figure out if there's someone we can file a claim for. If the VA doesn't know yet, we need to try to quickly file notice with the VA or the higher level of court if we have something pending that we found out our client had passed away. Express our condolences, of course, and then ask for a copy of the death certificate when it becomes available. So almost all of these deadlines will all the filing deadlines will be within a year of the veteran's death. So we let the survivors know that. Also, yes, to let them know that they should keep all invoices and receipts related to the final sickness and burial for proper reimbursement, and also depending on which person you're thinking of substituting to make them eligible for substitutions. But it's, at this point, we let them know that we don't have any contract with them. They're not obligated to use us if they want to file for benefits or enter into a fee agreement with our firm. There's other options. I often, if it's a DIC claim that's going to be super simple, then I've, told plenty of people, it's like, you can file for DLC. If they deny it, let me know, but this should be an easy grant. But it just kind of depends on the situation. Some of them don't want to do paperwork at all. Some of them are well-versed and are happy doing it. So, and we will assist them to the level they want. Close my. Sorry about that. Gotten blocked. Okay. So there are the benefits that they could potentially surviving spouse, child, or parent could be eligible for dependency and indemnity compensation. This is a claim that you file when the veteran has had a total rating for the 10 years immediately before their death, or it can be 5 years if it was between their discharge and their death, unless they were, and then yes, if they were a prisoner of war who died after 1999. And they had a total rating at least 1 year before death. You can also get DIC benefits when the veteran dies from a service-connected disability or disabilities, or if they were contributory cause of death. This leaves some room for creativity in terms of, what constitutes a contributory cause. We have a current case that a veteran died of cancer, but we're arguing that, his psychiatric disability was a contributor to cause the court because he refused treatment because of it. And his, doctor says, yes, his symptoms interfered with his ability to get treatment. There's also survivor's pension. Must have served during a wartime period, and this is based on survivors' incomes and assets that are set. Limits are set by the VA. I can't remember off the top of my head what it currently is. And then, yes, we don't usually do the burial benefits, but we will if, they ask and we're filing the other issues. So on your application for DIC benefits, survivor's pensions, and you're also can check the box for accrued benefits. If a claim was pending when they died and you have an eligible substitute, then you're going to check this box and say, I want DIC and accrued benefits. You will also need to file at that point a 21P 0847, which is the request for substitution. The 21P 530EZ is the burial benefits application, which if we're submitting, we usually submit with that. And then we had not been submitting the VA form 21P 601 for accrued benefits because we feel like, no, that's what the form is for. There's already a form for the accrued benefits. Why do we have to submit this one too? But the VA keeps asking for it, so sometimes we just give it to them instead of fighting with them about whether or not it's required. And then once you get these forms in, you're waiting. So if you have a pending claim and then you have a deadline upcoming, the VA is supposed to toll until they grant the substitution, and then you'll have time to submit the appeal on whatever that pending deadline was. I generally just like to get the argument in at the same time just to be safe and not have to track it later, because substitution is all over the place with the VA. I find that sometimes they do it really quickly and other times they don't do it till 9 months later or over a year later. And then at that point you're like, okay, wait, now we have to go back and do all these appeals. But it's kind of a personal preference. And then when they are granting these benefits, it's important to look at these decisions closely to see what they actually address. Because sometimes they'll just grant the substitution, but they don't acknowledge that, hey, there's a DIC claim as well that you haven't addressed. So that can be frustrating when you're dealing with these things. And then if you also have a client at the CAVC or the Federal Circuit, you have 1 year to do a substitution. Sorry, I don't know why I'm blanking on this. Yes, the VA requires the attempted substitute survivor to apply for substitution at the VA within 1 year, and for VA to have granted that request for agency level substitution. And then Federal Circuit just requires you to have applied in 1 year. There was one other thing I was thinking of when I was reading that about substitution, but I lost it. Going back to substitution at the agency level. But it's gone, unfortunately.
Sara, for CAVC, let's say the client dies within their 120 days, but really close to the 120 day to appeal the board decision. I know we've dealt with this a couple of times, but like, how do you satisfy the court when you're like, hey, we intend to appeal this, but substitution has not been granted yet?
I think, you just notify the court as quickly as you know, and say you're trying to get a hold. so we have this case right now where we're trying to get a hold of the potential substitute and just haven't been able to for a couple months. So the court may come back at some point, I think, and say, you either prove substitution is happening or we're dismissing this case.
So there's not like tolling automatically like there is for other appeal deadlines upon.
Well, no, I think there would be. Actually, I don't know.
I know it seems like a crazy question because I know I've had multiple cases, but it seems that I get lucky and they always end up granting substitution really quickly and we can get it in on time. But I just had that where I was like, okay, I don't know what happens. But so I know Claire said that if you've already filed, you can move for a stay, but if you have, like, the client dies before you file the
done the
appeal.
notice of appeal, yeah.
Sorry, did you say my name? Or are you trying? Because I've had clients die at all stages. So you were saying like towards the end of the 120, and we do or don't know a family member?
We want, or let's say we have a substitute, but they, or whatever, like they're mourning the death of their loved one. Let's say they die on the 119th day. And what do? You have everything, but VA is not going to issue their decision. But is there a tolling of a single, or however much time? Does that get told like it does at the
If you're talking about the court rather than VA, then you are actually fine and you can submit it yourself with nothing but vibes, because basically what you do, I mean, like, because this happens a lot, right, where somebody calls you the day their notice of appeal is due, and you don't need their signature on anything yet. You can just file the notice of appeal, file your notice of appearance, and then they follow it up with, hey, show me that you had any right to do this by sending me the retainer. And, and they'll just dismiss if you don't. So like, for example, I had a guy who lost his house in a tornado, and I found him once and I got filed for him, and then I could never find him again. And I filed for stays and I filed for extensions, and we gave him months and we couldn't find him. And then we just kind of had to close the case. But I was fine just filing that and then going from there. And it can be confusing, but I think I would put the spouse as like the name of the person, but then I'd have a little asterisk and a little note, saying what had happened. So it does help the VA to move faster on substitution if they know the court is waiting for them. So I do find that helpful sometimes, occasionally.
Thank you.
Yeah, I asked Katie because I actually don't practice at court. I only practice at the agency. So I was like, I'm not sure. But I think that the question too is if the client dies, that, which obviously if they're represented, you're going to know whether you're doing before them, but would that toll, I think the client dies within the time period, is it the 160 days, if they die on the 159th day, and then you don't do it, you still have a year from the date of death to file a substitution. Would that allow you to still file a notice of appeal outside that? Does that toll that time period?
That was partly my question. Like, what if substitution is not granted and you just found out around the 120 mark? Does that substitute claimant just lose the opportunity to appeal that, or then you're stuck doing a supplemental claim?
I think if you file, I mean, from the way I look at it, it's you file the substitution within a year of the appeal period, then that told it. And then you could still appeal. I know that's how the agency works. I don't know. I think the court
Probably file it in a way at the court anyway, just to kind of belt and suspenders it and everybody know what's going on. But yeah.
Right. I think we're getting into a weird hypothetical where
we just had this, but they granted substitution right before the 120 days. Like, he died right after the board decision, and within 4 months they granted, and it was like, okay, what would happen if that didn't work? Like, then what? So
it's really just a placeholder. A notice of appeal is a placeholder, and you can follow it with everything else later. So
well, they only give 14 days though, right? initially they say, okay, you have 14 days.
Oh,
to
yeah. They
complete.
say 14 days, and then you ask for 45 days, and then you ask for 45 days again, and then you ask for a 30-day stay. But like, if they know what's going on here, then they'll just, it's not a problem.
Okay. So notify the court as soon as possible about the veteran's death, or the claimant's death. And then yes, get a secretary's position regarding a stay while you gather the documents needed for the substitution. And then get the secretary's position again and move to substitute the survivor as appellant. And then yeah, they might, do it a show cause asking why it shouldn't be dismissed, and you're gonna have to respond to that. But in general, you have that year, as far as I understand, from the date of death to try to get to at least file the substitution. I think that's it for that. Were there any questions? Let's see. So in the chat we have, oh, that was already on the, yes. Claire says, yeah, if you already have an appeal filed, you can move for a stay. And then yes, Adam had a comment about the receive malpractice for, once talked to an Illinois Supreme Court to get guidance on whether a non-attorney Social Security representative needed to follow specific rules and practice. They were very much like, oh, we're not interested in that, and absolutely defer to federal government on non-attorney practice in front of the VA, SSA, and federal immigration courts. To the point that when they receive a malpractice complaint by a non-attorney practitioner, they just hand them the federal agency info of complaints. Okay, good to know. And then yes, Claire points out some OGC attorneys will get really mad if you fail to notify them, and could submit retaliatory motions. So something to be aware of. I mean, I think that's, again, the whole point. It's client communication, but it's also just communication in general is so important in every practice. And when you try to be as good as possible about, keeping the VA informed when you find out that a client dies. All right, are there any more questions? If not, I will let you guys go. Thank you so much for joining. And as always, feel free to reach out to myself at Sara at carpenterchartered.com, or I'm sure Laura would be willing to address questions as well. Have a good rest of your Tuesdays.
Thank you.
See you at Nova.
You won't see me at Nova.
You're not
Put it
gonna be
that way.
there? Oh my gosh.
I know.
Oh man. Well, that's okay. I finally get to meet
You get to
every-
meet everyone else, though, which is
almost
exciting.
every, oh, I don't have my camera on. Almost everybody else.
Yeah.
I'm looking forward to it.
Yes, I'm very sad I missed you, but I'm going to Ireland, so.
Oh, that's way better. Okay. You made the right choice. Good call.
Thanks.
All right, have a great day.
You too. No.